Good morning or good afternoon. Well, I was assigned a topic pertaining to legal issues, no, that should be avoided in real estate transaction. Maraming nagtatanong sa inyo tungkol sa SPA, Special Power of Attorney. Kailan ba valid or hindi valid yung Special Power of Attorney, no? Now, I would like to discuss about the special power of attorney in connection with conjugal properties, no, owned by husband and wife, na hindi na nagkakaintindihan, hiwalay na sila, although hindi pa annulled yung marriage, no? Okay. There are situations where, sa atin kasi ang problema natin mga brokers, ganito if we are presented with a pretty good-looking SPA, tama na yon. Okay na to, kompleto na to, no? But then, I think we should do some, extra efforts, no, in seeing to it that the special power of attorney is valid. Now, first of all, the special power of attorney, no, in the cases of yung mga hiwalay na husband and wife, you should see to it that you are authorized to sell. Halimbawa, husband ako, no? Now, we're no longer, living together. And dapat yan, make it sure that your special power of attorney is valid in the sense that it really authorizes you to sell. Number two is that there must be an authority for you to receive the payment. And the payment will be in your name. Dapat naka-indicate sa special power of attorney yan, no? And then, I will also add a provision in the SPA that the payment on the property shall be considered payment to the husband and payment to you, to the wife. Kasi chances are, baka maya-maya sabihin ng wife, hindi ko naman inaalaw yan something like that, no? So there must be a provision there which says that the payment shall be for the husband and for the wife. Maliwanag yun? Yeah, okay. Sa conjugal property kasi merong two situations dyan Yung situation na where the non-consenting spouse, halimbawa yung wife, has knowledge or has no knowledge or does not consent to the sale of the conjugal property. Void yun. Void yun. Dapat tignan nyo yun. Kasi nakakahiya naman, baka maya-maya, andyan na yung non-consenting wife, no? And he will file case against you that will delay or that would even deny you the payment of your commission, no? Something like that. Now, mayroon na situation where the consent, no, or the wife has knowledge but has no consent. Voidable yan. So ingatan nyo rin yon. So dapat talaga may consent, may knowledge yung wife. So in the case of a conjugal property being sold, no, if the non-consenting wife has knowledge but does not give any consent to the sale, that would make the sale voidable. Pagka nagdemanda na yung non-consenting wife, kayo rin mapiprejudice nun, no? Most likely, hindi kayo mabayaran ng commission o kayo madidelay yung commission ninyo. O yun ang ingatan natin sa SPA. Isa pang nakikita kong legal issue rito na dapat i-avoid nyo tungkol sa yung sinabi ni Robert na proximate cause Okay. Ang proximate cause kasi, parang it's present in a situation where yung broker, pinag-meet niya yung buyer sa yung seller. In-introduce niya. Lahat ng papel binigay niya dun sa buyer And then all of a sudden, na-edge out siya. Nawala siya sa transaction. Hindi na siya included sa thread, no? And then he's no longer being informed of what is happening. Okay? Now, to me, as a lawyer, I would say that you're entitled to the payment of your commission. kahit na pinabayaan ka na sa huli. Kasi sa real estate transactions natin, di ba? Pagka nag-offer ka, real estate service na yun eh. So I believe that as a lawyer, even if you are edged out doon sa final stage ng transaction, still you are entitled to the payment of your commission. Pero hindi ganun kadali. Hindi ganun kadali, no? Everybody would know that, it's hard to get the payment of your commission, no? So ang sinasuggest ko sa inyo, dalawa. Document everything. Dapat nakadokumento lahat yan. And secondly, siguro mag-establish kayo ng magandang relationship ninyo sa mga kliyente ninyo, no? As a matter of fact, kung tatanungin mo ako, mas importante yung yung good relationship with your seller or buyer, no? You may not need the documentation anymore kasi mahihiya yan. Your client would be morally obligated, di ba, to pay your commission. Pagka maganda yung relationship mo sa kliyente mo, di ba? Pero importante rin na i-document mo, you have to document everything, no? What I mean is, kung magpapadala ka ng email mo, siguro pa-acknowledge mo yung receipt, di ba? O kaya nagpadala ka ng sulat, patanggap mo. So the bottom line is, no, you have to reduce the transactions, all your transactions, all what you have been doing in writing. Kasi pagka hindi, mahihirapan kayo, no? Ngayon, kung mahihirapan kayo sa ganyan, the bottom line is, pumunta kayo sa lawyer and then you file a case in court. Something like that, no? But again, siguro ipakita niyo sa kliyente niyo that you have been keeping records of what you have been doing, no? Kasi kung alam nung buyer o alam nung seller mo na you have complete records, no? Mahihiya 'yon. I mean, he will not be messing against you. Ang mangyayari niyan siguro, matatakot siya, babayaran ka na lang, no? So I would suggest that you have to do documentation, document everything, and maintain good relationship with your client. Ganun lang. Mahirap kung wala kayong dokumento, no? Kasi sa real estate transaction, everything should be documented. Okay? Everything should be documented, no? Okay. As I said, kahit na initsapwera kayo sa uli, entitled pa rin kayo ng commission eh. Dapat full commission yan. Pero if worst comes to worst, no, pwedeng i-apply yung principle of quantum meruit eh. In such a case that what you deserve, you should be compensated, no? Alam mo, ganito yung ginawa mo lang. I mean, you have not finished the transaction, no? Then you are entitled to a compensation up to your contribution or up to your participation. Tama naman yun eh. Ordinarily, if you file a case in court and seek collection of your commission, di ba? Ang ina-apply ng court dyan, yung principle na, okay, gumawa ka niyan, so you should be compensated, no? But if you were not able to finish the transaction, you will be compensated based on quantum meruit, no? Ang isang principle na ina-apply ng court dyan, it will be unjust enrichment on the part of the seller, yung hindi nagbibigay ng commission, na hindi ka bigyan ng commission. Kasi in the first place, wala naman sila eh, were it not for you. I mean, the seller and the broker would not have met if not for you. The buyer would not have known, di ba, na may property for sale if not for you. Or vice versa, di ba? So kailangan talaga, I mean, ang suggestion ko, you have to document everything and at the same time, maintain good relationship with your client. Okay. Yung statute of limitation, yan eh. Tignan mo yung dokumento mo. Mayroon bang limitation yan, no? If there is no period fixed, it will be for 10 years. 10 years yan. Yeah, 10 years, no? To go after the payment of your commission. Mayroon ganyan. And then, mayroon pa yung principle dyan, statute of fraud eh. anything in excess of 500 pesos shall be proved by document. In other words, kung 500 lang naman yung kiniklaim mo, you can tell the court, no, verbally, or you can argue orally that, you have a claim of 500 pesos, and therefore, even if you have no document, that will be sufficient, no? But under the statute of fraud, if your claim is over 500 pesos, you have to have some documents to prove it. Okay.
In view of ayaw po naman ng authority to list, kasi in case of ngayon, 7.5 million na list, ayaw po naman ng authority. But we have to record that may record kami during the conversation with the meeting.
Okay. To me, that would be sufficient, although I would say that it would have been much better if you have the authority. If you have the authority, no? You can prove your claim by circumstantial evidence. I mean, if you don't have the authority, you have the yung mga tape recorder mo, di ba? O kayo mga exchange of, communication, calls, text, etc. So you can prove your entitlement to a commission by circumstantial evidence. Yeah, okay yon. Ang nakikita ko pang legal issue, yung magbebenta ka ng inherited properties, no? Inherited properties. If we talk about inherited properties, mayroong dalawa yan Mayroon yung on the basis of a last will and testament, inherited property yon. Pagka wala namang last will and testament, you have the what we call extrajudicial settlement of the estate of deceased person, no? Yon. Sa last will and testament, kung dapat siguraduhin niyo yung family tree, dapat malaman ninyo kung sino-sino yung mga compulsory heirs diyan. Kasi pagka yung isa hindi included sa last will and testament, that's what we call preteritated heir, no? And that preteritated heir can go to court and seek the annulment of the institution of the heirs, yung mga compulsory heirs. Okay. Yung mga provisions sa last will and testament tungkol sa donation, halimbawa yung property, dinonate sa isang tao, di ba? Valid yon. Pero when it comes to shares of the compulsory heirs, no, invalid yon. Kasi pwede mag-seek yung disinherited heir o preteritated heir ng nullity of the institution of compulsory heirs. Sa naman, sa extrajudicial settlement of the estate of deceased person, ang tawag yan sa mga hindi ini-include na heirs would be excluded heirs. Hindi yung preteritated heir, no? Now, in the case of a excluded heir, yung last will valid pa yon. Last will valid pa yon, no? It's valid insofar as the portion of the of that undivided portion pertaining to the consenting heirs, no, is valid. Although it would not be valid insofar as the excluded heir is concerned. Kaya pagka nagdemanda yan sa court, mape-prejudice yung payment ng broker's commission nyo. So, try to exert, extra effort. Sa batas naman natin, walang magic formula Walang quick fix dyan no? Wala pa akong nakikitang batas na nagsasabi na bayaran ka kaagad-agad or what, no? So, in all cases, I would say that you have to document your transaction and you have to maintain good relationship with your seller or with your client, as the case may be, no? Yeah. So I think, Robert, that's all. Okay. Yeah.